Assistant Attorney General Clarke received her JD from Columbia Law School and her BA from Harvard. Assistant Attorney General Clarke, you are recognized for 5 minutes.
Chairman Cohen, Ranking Member Johnson, and members of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties. My name is Kristen Clarke, and I serve as Assistant Attorney General for the Civil Rights Division of the U.S. Department of Justice. And I want to thank you for the opportunity to testify today on the department's work to implement and enforce the Voting Rights Act of 1965 and the need to revitalize and restore the act. The Voting Rights Act is, as President Johnson said, one of the most monumental laws in the entire history of American freedom. It is a law that has helped to truly transform American democracy. However, the progress that we have made is fragile as we watch the current resurgence in attacks on voting rights. We have seen cuts to early voting periods, new and burdensome restrictions to register or vote, racially gerrymandered redistricting plans, polling sites eliminated or consolidated in communities of color, eligible voters purged from the rolls, restrictions on civic groups seeking to help voters participate in the process, and more. I am here today to sound an alarm. In 2013, the Supreme Court's decision in Shelby County versus Holder suspended the preclearance process, the Justice Department's single most powerful and effective tool for protecting the right to vote. The department's ability to protect the right to vote has been eroded as a result. For the Justice Department, restoration of the Voting Rights Act is a matter of great urgency. Before Shelby County, the preclearance process enabled the department to swiftly review and block the implementation of discriminatory and unconstitutional voting practices in covered jurisdictions. While Section 5 was in place, the Justice Department blocked over 3,000 voting changes, helping to protect the rights of millions of citizens. Evidence of discriminatory purpose, intentional discrimination, was found in over 60% of voting changes blocked by Section 5. In addition to blocking discrimination, the deterrent effect of the preclearance requirement was undeniable. The Shelby County ruling has given a green light to jurisdictions to now adopt voting restrictions. Today, these laws can only be challenged through long, protracted, resource-intensive, case-by-case litigation. The department knows well the burden that comes with the case-by-case approach by way of cases that we've brought recently in states like Texas and North Carolina. This gives to jurisdictions what the Supreme Court memorably called, quote, the advantage of time and inertia. Before Shelby County, jurisdictions had to meet their burden of proof by demonstrating that these rules were not adopted with a discriminatory purpose or would not worsen the position of minority voters. Today, discriminatory laws are allowed to take root immediately, impacting voters and corrupting the electoral process. We are on the cusp of another potentially transformational moment. Redistricting is about to commence. Virtually every jurisdiction that elects its members from districts, from state legislatures to county commissions, school boards, and town councils will be required to redraw district boundaries. New 2020 census numbers show the U.S. has become an increasingly diverse nation, with population growth attributable to increases in the number of people of color. Absent congressional action, this redistricting cycle will be the first without the full protections of the Voting Rights Act. Without preclearance, the Justice Department will not have access to maps and other redistricting related information for many jurisdictions where there is reason for concern, even though this kind of information is necessary to assess where voting rights are being restricted and to help inform how the department directs its limited enforcement resources. In 1965, Congress enacted, and in 1975, 1982, and 2006, reauthorized a statute that provided the strong medicine needed to remedy voting discrimination and enforce our Constitution's commitment to ensuring that no citizen's right to vote would be abridged on account of race or color. Congress has broad enforcement powers and must act now to restore the Voting Rights Act, to prevent us from backsliding into a nation where millions of citizens, particularly citizens of color, find it difficult to register, cast their ballot, and elect candidates of choice. We look forward to working with this Congress to revive this bedrock civil rights law. The Justice Department stands ready to support Congress in protecting the voting rights of all eligible Americans. Thank you.